He joins us on Thursdays, and sometimes we have a little effort getting it all over to him. But he is the former assistant U.S. attorney, and now he's a practicing law in Southern California. David Katz, everyone.
Great to be with you.
Yeah, thank you, David, for joining us. So I mentioned this abortion case in Texas. I wonder if we could start with that, and then we'll get to Trump and what the apparently this special grand jury that was impaneled heard. But can you tell us about this case as it churns through this conservative judge's court in Texas?
Well, the case in Texas, Mark and Kim, is very troubling because it's been steered to a Trump-appointed judge who actually is a former assistant United States attorney, as I am, not in Los Angeles, somewhere in that area in Texas. But then when he left the office, instead of becoming a judge or a practitioner, taking different kinds of cases, like I take white collar cases, he went to work for a so-called Christian advocacy organization. And they push the very kinds of things that the plaintiff is pushing here: restrictions on abortions and now restrictions on abortion medicine. As people will recall, it used to be that they needed 60 votes. There were filibusters even for federal judges, but that went out. And so now a federal judge can be confirmed with just 51 senators. And that's what happened with this very right-wing, very pro-Christian advocacy group lawyer. He was appointed by Trump, and he was approved, I think, something like 51 to 49. Every Democrat voted against him. He got Collins voted against him. Well, that makes 49. So the other 51, Romney didn't save us on this one. Murkowski didn't save us on this one. And so they knew exactly what they were getting with him. And then, unfortunately, what they do is they steer cases. The right says that these cases about immigration get steered to some friendly judge in San Francisco. Whether that's true or not, these cases that are against women's rights to choose seem to somehow get cherry-picked. They seem to get steered to a judge because they say they want a nationwide injunction, and so they can take it to any judge in the country because this drug is distributed throughout the country. And so they pick this right-wing pro-choice, anti-choice judge. They steer the case to Amarillo, and before you know it, this one federal judge has the power to issue a nationwide injunction, which, hold your breath, affects women, young women, poor women in blue states. This is not just something in this bailiwick somewhere in the boondocks in Amarillo, Texas. This would apply to every woman in the country, and the only thing that could undo it, if this judge does it and issues a stay or does not issue a stay, or if he issues an order that his injunction applies nationwide, is that the government and this manufacturer of the drug and the advocacy groups on behalf of women would have to run to the Fifth Circuit. Unfortunately, the Fifth Circuit Court of Appeals is the most conservative in the country. And so if they didn't dissolve the order, if they didn't issue a stay so that women could still get this necessary medication, which is how more than half the women in America actually get an abortion. This is after a woman finds out she's pregnant. Let's say that takes a month, 5 weeks. Then she has about another 5 weeks that she can use this medication in combination with another medication, which is also readily available. There's a very, very high chance of terminating the pregnancy, and extremely safely. So the FDA determined over 20 years ago that it was very safe, it was very effective, and now they're going back at a 20-plus year decision because they found a friendly judge who will listen to what I consider their frivolous, ridiculous argument. And the United States government agrees with me and is on the side of the company that manufactures this. But again, it's a big hoop-de-doo in Amarillo. A 4-hour hearing was held yesterday. The judge did everything he could to keep it secret. He effectively issued a gag order, although he didn't call it a gag order. A lot of the media wasn't there. A lot of the protesters who would have been there didn't find out about it in time to get there to protest. Amarillo's kind of in the middle of nowhere, not near most major transportation hubs in Texas. And now it's been taken under submission, and this sort of Damocles is hanging over women's heads. I mean, everyone's heads, but women, of course, are going to be the most affected. Young women, poor women, women who need to take this pill because they've decided to choose. They've decided in that circumstance in their life, they want to terminate that pregnancy. They want to do it with these pills.
I have a question for you. Mr. Katz, and there should be, it seems like there should be rules where you have to recuse yourself if you have a history of, say, working on one side of an issue. So in this case, if you have a person who was worked for, anti-abortion groups, and then gets a seat on the bench, it seems like there should be an automatic recusal of some such. Is that not?
Well, Kim, the argument is if you have a personal, especially a financial interest, that's sort of a recognized conflict of interest. If you owe 100 shares of Exxon and it involves Exxon in distributing its products, then normally a federal judge would recuse himself or herself because of that conflict of interest. If the alleged conflict is more ideological, then you get into the area of, well, wait a second, people want to have a change in politics, including they want to have one through the constitution of the bench. If pro-environmental people can't get judges with pro-environmental views who belong to pro-environmental organizations, if you can't have a federal judge who's been in the Sierra Club or who's paid dues to, Doctors Without Borders, but, sometimes it stings. It's one thing to have a member of the Sierra Club. It's another thing to have this person who is a full-time advocate. But you know what the argument's going to be, Kim? RBG was a full-time advocate for women's rights. She argued it in front of the U.S. Supreme Court, and it was considered a great victory when she was put on the bench. And then she could, they would say that this judge out there in the middle of Amarillo, Texas, is the pro-life RBG. Wouldn't that be their rhetoric?
Sure, and they'd say, "Hey, look, that's what you want," as you just said, David. You want the philosophies of certain people to underpin their decisions. So why should that be held against them? I mean, it's horrifying to think of what's likely going to happen. And I wonder if you can just take a step back and explain again. And we saw this with the Muslim ban, how a judge was able to, enjoin, I guess, or block it from actually coming to pass. But I wonder if you can explain again how our system is set up so this judge out there, as you say, sort of in the middle of, nowhere-ish, can affect this country and affect women here in California.
Well, imagine that some kind of pill that was sold all over the country was found to have some kind of poison in it. You would want it taken off the shelves, and you wouldn't want it taken off the shelves only in San Francisco or only in Amarillo, Texas. You would want to give a judge the power in that situation, a true emergency that was national, to issue an injunction that was an emergency injunction and truly national. The thing is, this is obviously game playing, because this pill was approved over 20 years ago. It was held after full hearings by the FDA. They have what have always been considered specious arguments against this medication. The judge even asked them, do you have any precedent for any federal judge in America having done what you're asking me to do? And they had to say, well, no, but you ought to do it. You ought to do it because it's a dangerous judge, a dangerous drug judge, and we say so. And their specious argument is that supposedly the FDA did tests on certain kinds of situations with women, and then the real life situations are different from what the FDA tested for. Number one, the FDA has a right to decide what are the expert tests, what are the things that really give validity to the orders that they then issue or the permissions that they then give for people to use drugs. They do this every day. They do this with penicillin. Penicillin is 3 times more dangerous than this drug, because this drug isn't dangerous at all. I mean, really and truly, are we going from this to banning penicillin because some quacks, I'll call them that, some quacks, some advocacy group that doesn't like penicillin, cherry picks some federal judge, one in America, and has an order like that nationwide. Now, people say, well, the Court of Appeals would immediately strike down an order if some far out judge in America, some federal judge abusing this power, issued a nationwide injunction. Wouldn't a Court of Appeals with 3 judges then strike down that one judge's order? Well, maybe yes, maybe not. We see things from the Fifth Circuit, where this southern Texas circuit. Remember, this is where they had the vigilantes, and you could go collect $10,000 by ratting on somebody that they helped somebody else get an abortion. They never struck that one down. That one went all the way to the Supreme Court and was kept.
So the most, David, the most radicalized state, I mean, or arguably, I mean, in the I guess it's it may be a photo finish, among the most radicalized states on this policy with a woman's reproductive right being imperiled this way, they will have control over the entire country's access to this medication.
They will. And, you know, the Ninth Circuit, let's say out here on the West Coast, which is not as liberal as legend would have it because Trump ended up having a lot of picks in his 4 years to the Ninth Circuit. But the Ninth Circuit can't undo it because it's not before the Ninth Circuit. Now, what somebody could do is start a lawsuit out here and get a ruling from the Ninth Circuit that, no, this drug should not be removed from the market. Then you'd have these inconsistent rulings where maybe in the Southwest and in Texas, you could not get this drug in any pharmacy. You couldn't get it by mail order. The company couldn't send it to you, but they could send it to you on the West Coast in the Ninth Circuit. Those kinds of cases are the ones that go straight to, or usually go rapidly to the U.S. Supreme Court, because there's inconsistent law in the United States, depending where in the United States you are, whether you're in Texas or on the West Coast. I think that if this one goes to the U.S. Supreme Court, I think the U.S. Supreme Court would not allow this nationwide injunction. But it'll be a lot of worry before then, because you have 3 Trump appointees on the U.S. Supreme Court, and people kind of worry, oh my God, what's the Supreme Court going to do? And after they struck down Roe v. Wade and they overruled that, right, with Dobbs, people think, you know, they're really capable of anything, especially when it comes to this highly politicized issue, this issue of a woman's right to choose and a medical abortion. It's so important for people to understand what this is about. Over 50% of women do not have an abortion the way a lot of people think about it, where they go to a doctor's office and they have a procedure. They find out they're pregnant, and within the next 5 or 6 weeks, they take these 2 pills, which are extremely safe, extremely effective, and result in her having a medical abortion. And that's what's done all over the country, and especially what's being done in these red states, because in a lot of these red states, you have to drive 200 miles to try to get an abortion, right? And so you can do this, and you can just get it over, you can get it over the counter. I don't think you even need a prescription. The company that makes this, of course, is going to take a huge economic hit. They have a huge interest. They've intervened in the case to say, this is totally safe, this is totally effective. One last thing, the judge is trying to figure out if he doesn't attack this 20-year-old decision by the FDA, maybe he'll attack some of the more recent ramifications, some of the more recent iterations of it, like that you can do it by telemedicine, that you can do it without seeing a doctor, those kinds of things. And he'll say that they have not been properly approved by the FDA. Of course, they've all been approved by the FDA. And this is just earth-shattering. It really is the idea that you can attack FDA judgments that are well settled and not have the U.S. Supreme Court decide that the FDA is all wet and all unscientific, but to have one judge do it around the country. I'm not trying to do a parade of horribles, but once you go past this pill, which would be a horrible ruling, you can get into things like penicillin. You can get into all those people who didn't agree with the COVID vaccinations. Can you imagine they go have some judge down in Florida appointed by Trump decide that you can't take the vaccine for COVID, or there's a new variant, and someone decides the FDA or the CDC hasn't properly tested it, and now we have a nationwide injunction. So this one's really dangerous. The people who are getting worried about this are right to be worried, and everyone's holding their breath because the judge hasn't said exactly when he's going to decide, but you figure he's probably going to do it pretty promptly. Right. And it seems about 50-50 that he'll issue this nationwide injunction, or he'll issue a nationwide injunction which is tailored as to something like telemedicine, or that you have to see a doctor before you take it, which will still restrict the rights of millions of women in blue states to have access to abortion medication.
Parade of horrible is right. And it seems like there's not much recourse for women. You know, you're talking about then a second case at the Ninth Circuit. All that takes time, and think of all the people that'll be affected between now and then.
Right, there's young women right now, today, who are worried about getting that medication. When you look at these states that now, the red states that are now banning abortion, this has become even much more common since Dobbs, that people are getting the medical. And, you know, you see these other cases that are just terrible that are happening here, where some states are trying to make it, I'm not kidding you, murder for a woman to get an abortion. And the people that she communicated about whether she ought to get an abortion, whether in her family situation, her life situation at the moment, this is really something she ought to consider about doing. For giving that advice and helping a young woman, her friends who are helping her decide that, they're talking about prosecuting them, for a crime, for murder. I think South Carolina is talking about making it illegal, making it murder to get an abortion. So, I mean, what we worried about when Roe v. Wade was overturned, a lot of it's really coming to pass. And I think a lot of people thought, well, my God, you know, we're going to have this maybe in South Carolina, in Texas. The ruling we're talking about now would affect women in California until
yeah.
the Fifth Circuit or the U.S. Supreme Court dissolves it. This ruling, if this judge in Amarillo, Texas, appointed by Trump, knowing his views, approved by 51 senators and opposed by 49, would become the law of the land until either the very conservative Fifth Circuit overturns his ruling or until the U.S. Supreme Court with 3 Trump-appointed judges. I'm going to make my pitch. I've made it on your show. We need 11 or 13 Supreme Court justices. We
Oh
can't
my God, yes.
We can't keep living like this. Every issue, every environmental issue, every women's health issue, maybe whether we can get vaccinations or not for the next pandemic that comes around, is up to these 5. I mean,
the
why
court has to be expanded. And then, as Kim says, the amount of time that will take to even go through the process as it is currently laid out. We started so late. I've got to wrap up, and yet I don't want to wrap up without asking David Katz about the revelations in the Trump grand jury. They impaneled this grand jury. It was an investigative grand jury on the Trump case. I only got another 30 seconds or so, but David, please.
Let me get my shot at it. There was an old movie before your time called The Mouse That Roared. I call this the misdemeanor that roared. And I do think that Trump ought to be, pursued for things that are righteous criminal charges. But I think this one is very problematic, guys. I think there's a very good chance that he would beat it or only be found guilty of a misdemeanor, and that would actually help his political career. I don't see any reason why the DA in New York should help his political career. There's also the problem that a lot of people are not mentioning of the statute of limitations. This happened 7 years ago. There's a 5-year statute of limitations in New York. Apparently, during the pandemic, it was extended, I think, for civil cases, but only about 6 or 7 months. 5 years plus 6 or 7 months, even if it applies to this, does not take you back to a 7-year-old offense. Now they say,
okay, but David, that's the New York case. In Georgia, the grand jury heard the call. They actually heard this call of him essentially leaning on the Georgia. It was not the Secretary of State. It was another Georgia election official to try to overturn the election. Does that change the arithmetic in your view in Georgia at all?
I would have said yes if you'd have asked me that in January. But, as of January, the grand jury there had heard what they'd heard. They decided, although it was sealed for a while, that these 12 people should be indicted. And in the last 2+ months, that DA down there in Atlanta, Georgia, has not charged, not just she's not charged Trump, she hasn't charged anyone. And she really needs to get moving on this for many reasons, one of which is that it's a Republican state. And while Kemp didn't do his bidding, didn't do Trump's bidding, and count the votes for him because he thought he had no legal power to do that. There is something he has legal power to do, and which is legitimate, whether we like it or not, and that is to pardon Trump on a state crime. So this state crime, if it finally ends up in him being convicted after all of it, and I think it has a very good chance, I think she should go for it. If Trump has a state pardon in Georgia in his future, bring it on. But right now, she hasn't done anything for over 2 months when all she has to do is to go into the grand jury with that report and with an indictment that she gets to draft and say, ladies and gentlemen of the grand jury, please vote guilty on this, and they will. And if she indicts 5 or 6 people, whoever they are, Giuliani, some of the other people that she seems to have very strong evidence in that case, let's see if they want to go to the state penitentiary in Georgia or whether they want to take their chance on the governor of Georgia, giving them a pardon. Because if they don't, they're likely to flip on Trump. That is how we federal prosecutors used to make our cases, and the cases that I see as a federal criminal defense attorney. They flip one person against the person above them, and the person doesn't want to go to jail. Now, in New York, Weisselberg apparently was willing to go to jail for 5 months. One last comment on this. People who think this is such a strong case in New York by the DA against Trump because it was a case that Michael Cohen chose to plead guilty to. Michael Cohen was in a lot of other trouble on state charges. And Michael Cohen could have very rationally decided that he would take this federal charge, whether it was that strong or not, even against him, because he didn't want to go to Rikers Island prison. He didn't want to go to Sing Sing Penitentiary in New York. He'd much rather get a federal charge than those state charges. But remember, he was in trouble for tax evasion statewide. He was in trouble for his taxi medallions that he not valued properly. and that they're going to rely on Stormy Daniels. This is a real mess, and they got to put her in the grand jury and get her under oath to explain what happened, because she goes sideways at the trial because she decides it's more, her bread is more buttered on the side of helping Trump than helping the DA. They're going to be shocked. They may be shocked anyway, but they're going to certainly be shocked if they don't have her in the grand jury under oath, telling exactly her side of the story, how she met him, how she approached him, how he ended up paying her this money, what happened with, some of her lawyers. She had Avenatti, she had other lawyers. I mean, you want to lock her in as well as locking Michael Cohen in. And then, as I say, it's a difficult case because to show the felony, you have to show that he specifically knew and intended to violate New York campaign financing law. And he's going to say, I barely knew the federal law. And Michael Cohen didn't explain it to me. And it was 12 days before the election. I had a lot on my mind running for president of the United States, besides how we characterize that payment. That's what he's going to say.
So just to review, New York case is a non-starter in David's view. The Georgia case, bring it already, David would say. And the abortion case in Texas is huge, titanic, massive. And we will talk to you next week, my friend. I'm sorry we're out of time. The great David Katz. Thanks, David.
Great to be with you.
Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.